everybody. Thank you for joining our webinar, which is entitled Don't Be Scared of the O-1B visa. Obviously fitting considering the week that is upon us, which is Halloween. For those who don't know, Halloween was actually started in Ireland back in the day. So thank you for being here. We are going to kind of go over the O-1 visa for content creators and influencers. I'm going to talk through some of the evidence that we typically see. We got some questions ahead of time, and I've done this webinar before, so I have some frequently asked questions that I will address. If you do have questions, feel free to pop them in the chat and I will try to get to them later on. But for now, we will kick off. Just note that that we are recording, as I think we mentioned. So just be mindful of not sharing any confidential info in the chat. Okay, so let's get started. I think this should take around half an hour. I'm not sure if it was blocked off for longer, but I'm going to try and get through the content in about 30 minutes. So let's get started. So it wouldn't be a typical, law firm webinar if I didn't give a disclaimer. So just noting that, please don't rely on anything here for legal advice, and you should always consult with an attorney. And I am not your attorney. And by watching this, it's not creating an attorney-client privilege here. So for our firm, this is our contact info, pretty much on every single platform that you can imagine. There's all our info there. And also I am on pretty much everything too. US Visa Lawyer is my handle, except for on TikTok where it's Immigration Lawyer Fiona. But yeah, please connect with me. LinkedIn as well is somewhere that I share a lot of info. So you probably don't need me to say this, but immigration policy is changing constantly. I mean, just earlier on today, there was a policy change in relation to, work cards and automatic extensions. So things are happening, especially with this administration. So it is important that you are kind of keeping up to date. On that note, we have a lot of resources in our firm. We have, various like newsletters, blogs, things like that. So hopefully, you can follow up on those and you can get those updates. Also, First Friday is something that we do, which is our it's the first Friday of the month we do a live kind of like information session like this, where an attorney will share some updates that had happened in the previous month, and then also will take some questions. And we have webinars on our YouTube as well. So today I'm just going to give you some brief info on me and background on the firm and some of our clients. And then we'll get into really the reason that everybody's here is to talk about the O-1 visa. I will chat about our approach, which is this three bucket approach, talk about the O&A versus the O-1B and defining field of expertise, and just kind of making our way down through the evidence in the way that we have tried to, think about it, which is these three buckets of evidence. So hopefully it is easy to digest. That's our goal, is to make this as, as accessible as possible. So O1s are definitely a niche practice within immigration, O1s as a whole, I would say. Not every immigration attorney is going to have O1 experience. It just happens that given that we do a lot of O1s, and I've been doing them for, my career, which has been nearly 20 years, our firm has a lot of O1 experience. So yeah, I came to the US as an international student, which feels like a long time ago because it was. And this says managing attorney, but I'm now the founding partner at the firm. My brother-in-law partner, Ray, is the managing partner now. But I write a lot and speak a lot about immigration, especially on the O1 and the EB1A. I've written a couple of books, and I will share our guide as well that you will get a copy of that as well. O-1B guide for content creators. So this is a quote from one of our clients just talking about, the reason she chose to work with us was based on our expertise in O1 cases. And, we do try to make the process as easy as possible, which is our ultimate goal. So here's an example of some of our incredible clients, artists, content creators, influencers, musicians, things like that. And our office and where I am right now is based in 2112, which is a big music and entertainment ecosystem. And the benefit of that is that we're surrounded by a lot of creativity all the time. And it really is, it's a fun space for us to be in. And we just get to work with a lot of creatives through this ecosystem, and beyond. And so it's a fun place to be. So the O1, anybody who has ever heard me talk about the O1 will probably know that I reference the policy manual a lot because it is really the guidebook. I kind of consider this the guidebook for the O1. So we have the law that created the O1 visa, but it's pretty, sparse. And then the policy, so like the policy manual, like this, essentially adds meat to the bones of the law. So kind of expands on the criteria and things like this. And, prior to today, I just was looking at the policy manual just to see what updates, if the Trump administration had made, any updates that I was not aware of, and they haven't. So they have made essentially two different policy updates. You know, the first one you can see for yourself. It's obviously about relation to trans athletes. They've put it in. The O1 policy manual is for O-1A and O-1B. So this is the manual for both of those categories. And the second thing that they did was the Biden administration had changed the word alien. They'd removed that term and changed it to non-citizen, and the Trump administration has changed it back. So you will see references to alien, meaning non-citizen. So there are the changes. But what it really means then is that the previous guidance from the Biden administration that was actually pretty helpful is still, there. So this is a screenshot from a press release that was issued in March of 2023, obviously a very different time for immigration. And it was, it's the Biden administration was trying to modernize and update the policy, and they did that for O-1Bs as well. So they basically updated the guidance. You can see what they said, an appendix, which I think has been kind of moved into the main body of the policy manual, talking about the types of evidence that they will consider in O-1 cases. So, we still have this guidance, and we can use that guidance in our cases. So policy manual is always my best friend when it comes to really any case, but especially O-1s and then the extraordinary ability green cards, the EB-1As. So this is a question we get often. Is it hard to get an O-1? Can I get an O-1? My friend got an O-1. Can I get one? My co-founder, people often just want to know, is it difficult? And of course, typical lawyer answer is it depends. It really depends on your background, and it depends on, whether or not we think that we can present a strong case for you when looking at, what the law requires and the policy, and then in looking at your background. So I would say before we even get into anything in relation to like what is needed, we first need to work on our mindset. And depending on where you're from, this may be a bit of a cultural thing for you. So I'm from Ireland. In Ireland, it is pretty common in our culture to be quite self-deprecating, I think, and very humble, and it's also just kind of rampant in the culture to kind of take people down a notch, or people don't necessarily want to be bragging, or that's just kind of how we were brought up. However, now is not the time to be humble. The O-1 is about, stepping into all your extraordinariness. And it can be a little bit of an uncomfortable thing for people, but I would advise you to just put that aside and just really be objective about this. And you may be more extraordinary than you think. And this has actually happened quite a lot. And just happened recently where I was doing a consult for somebody who has, significant experience, and he was doubting whether or not he would consider himself extraordinary. But to me, based on the background, his background and the evidence, I felt like we could put together a strong O-1 case. And so this is actually a testimonial from an Irish documentary film producer. She was definitely put off by the kind of label of extraordinary. And as we started working with her and I suggested it, it actually was a great option for her when we got her case approved and then got subsequent O1s approved for her. So I think, she was able to just put that initial misconception aside and yeah, and we went for the O1. So just because we're looking to show extraordinary ability does not mean that you have to have, decades of experience. We have successfully done O1s for people from college, from the OPT, which is the work permit that you get after college. And that being said, the standard is high and it does require a lot of evidence and it takes time to prepare the case. Um, but it doesn't mean that you have to have had like a 30-year career in order to even consider the O1. I think it's worth it to put it into potentially in the mix, and especially for content creators and influencers. This can be a really good option for you because it is more of an emerging field. Like there's no one who has 30 years of like content creating experience. It's obviously a newer field. And there's definitely some benefits. There is no cap, so certain visas are limited in number, like the H-1B is a big one. The O1 is not limited, so it can be available any time of the year. And it's especially important, I think, as people are looking at just all sorts of options. There's been some, changes to the H-1B that are being litigated over. There's a new $100,000 fee. You probably saw that. But that's being, that 100K fee is being litigated as well. So just something to consider. So as I mentioned from the start, we think of the O1 in like three different buckets. And then the first of these buckets is proving that you have extraordinary ability in your field. The second bucket is the petitioner and the sponsor. And I'll break these down individually. And then the third is evidence that you're going to continue to work in your field. So while they are distinct, they are also related. But think of these into three different buckets. And when people ask me a question, I think, okay, what bucket is this related to? And what specific pointer are we trying to prove with this evidence? Or what does this question touch on? So the first thing is we need to prove bucket number one, that you have extraordinary ability in your field. So that really involves us defining your field of expertise. And this is where we look to the O1A and the O1B distinction. So the O1A is really science, education, business, athletics. And then the O1B is the arts, which is typically where content creators and influencers come into, or motion picture and TV. I said typically for the O1B for content creators and influencers because it is possible to fall under the O1A for science or education. We've had some clients that are medical professionals, so that the content that they are producing is more scientific or kind of technical in nature. So then they likely would fall under the O1A. It just kind of depends on the type of content. And same for, sometimes it's not always clear whether you're O1A or O1B. Like we had somebody that was doing kind of business related content for other content creators. So she was basically helping other content creators get more views. And so we were debating about, is this more business or is it more arts? And I think we determined that because it was more, while the content was business, it was all about like her creative strategy and, just kind of really thinking about target audience and just, it was leaning more O1B, the arts, so that is the option that we went with, and then the case got approved. So, and of course, we can't guarantee any approvals. We just want to say that the stories that I'm sharing is based on past experience and past clients, which we cannot use as a basis to say your case is also going to get approved. But we do have a great, we've had some great successes here with O1s. But so first off, O1A, O1B. And it really comes down to, in terms of like, let's say the business versus the arts, are your duties more on the creative end, like your day-to-day duties? Are they more creative or do they lean more business orientated? And it's not always clear. But I will say often our content creators do fall under the arts. Um, and here are some examples. We were working with somebody in the hair and beauty industry, and so they were a stylist, but they also had their own, brand of stores and different things like that. And the government was trying to say maybe this is more business versus the arts, but we pushed back and said no, it is more artistic. Like they're doing platform work and stylists, and it's based on their creative talent. And that case got approved. So it just goes to show you it's not always clear. We also were working with a nightclub entrepreneur that initially we thought was more business, but as it turns out, there was a lot of creative strategies. So it's important to note that it's not the field of expertise necessarily that dictates this. It's what are your day-to-day duties. So for example, if you were working in the field of athletics, so let's say you were working for a professional sports team, so that's athletics, which if you've expertise in athletics, it's O-1A. But if you're doing marketing, fan engagement, creative strategies, things like this for an athletics team, then that is likely O-1B. And that is a real life example as well that we had. So you can kind of see it's not always clear. So, but once we've determined O-1A versus O-1B, and the evidence might dictate that as well, we then need to break it down even further. And this is what we call the Goldilocks approach to your field of expertise. For those of you who are familiar with the Goldilocks fairy tale, we don't want the field to be too broad. So like saying you're just a content creator, that is extremely broad, and it is likely then going to make sure you're going to be compared to like every content creator. So we want to narrow it down a little bit. Is it lifestyle? Is it fitness? Is it beauty? Is it, what is the through line in your content? And can we give you a niche, or I guess niche, as they say here? Can we make it a bit more narrow? Now, with that being said, we don't want it to be too narrow, because there was some litigation and a decision that basically said that ranking at the top of a field of one is meaningless. So, we do need to show you're at the top of your field, but if there's nobody else in your field, that's not really going to help you. So you need to get that Goldilocks approach, not too broad, not too narrow, just right in between. And this is where we can help. We have a lot of experience with kind of assessing fields and trying to make sure that we just hit that sweet spot there. And it's not always immediately obvious. Like it's sometimes as we work through the case, we can really define this down, but just something to keep in mind from the outset. So once we've figured out that it's, let's say, O-1B, we've figured out that let's say you are doing you're a beauty content creator in the O-1B. Now we need to make sure that we can prove that you are extraordinary. And this is a case that I wanted to show because it's an illustration of, this is an actual case for a fashion designer, and you can see, the amount of evidence that's required. And yes, the government still requires paper filings of things. So we do kill a lot of trees, unfortunately, but this is the way we have to file these cases. In the past, we actually had to send them in duplicate. So we had to send this and then a copy. They have at least stopped requiring us to do that, which is great, but we still do need to prove a lot of, provide a lot of evidence. So the meat of the case really in an O-1B involves looking at these 6 boxes. And again, this is still under the first bucket, but it's often the only thing that people think about when they look at the O-1. And there's a list of different things. So showing that you've had a lead starring or critical role for distinguished companies. That is in the past. We need to do that in the past and the future. There's 2 kind of prongs to that one box. The second one is also lead starring role in distinguished productions or events. Again, past, future. I'll just run through them quickly. Press, expert recognition, major commercial, critically acclaimed success, and then high salary or remuneration. So I want to really, really stress that none of these are absolutely required. And I think this is a pretty common misunderstanding with O1s. People think, oh, I have to have press. You don't have to have press. Press is one of a potential 6. you do not need press. I will say that a lot of our content creator and influencer clients do not have press because they're getting traction on social media and it's not the same as just like a traditional type of like entertainer where maybe an actor or somebody is getting featured in media, like traditional media. So you do not have to have press. I will say, and also, okay, I could talk about this one slide for probably an hour, but I'm not going to because I'll give you more info in our O-1B guide. But just note that it's possible to, let's say, double dip. So for example, let's imagine let's go with this beauty influencer. So you're a beauty content creator and you have gotten a contract from like a major brand to do a series of like campaigns for them. So let's say, oh, it's coming up to like the holidays. They have this like, holiday themed, gift box and they want you to do a series of videos promoting that. Okay, we can show that you will provide evidence, any contracts, payments, screenshots of videos, engagement, things like that. And we'll show that you had a lead or starring role for a distinguished company. We'll prove that the role was lead or starring. We'll show all that you were doing these videos. That's your lead role. And that the company is distinguished. So showing that they are a household name, they have X amount of followers, things like that. So we will do that for that campaign. We can also use that evidence as showing that you've had a leader starring role in distinguished productions or events. So we can show that that campaign is a production and that you have had this like role for that in the distinguished production. So it's all kind of related, right? And so it's important that as you are, let's say, building your career and building your evidence, like make sure you keep evidence of all of these things. Make sure that you are tracking, your contracts, tracking also how long it is taking you to do these videos, because we can potentially use the money that you got, the compensation that you got. We could potentially show that that is considered high for the amount of work or the time that it took for you to do these videos. So the high salary one, it doesn't have to be like an annual salary. It can be significant remuneration, so significant compensation for like a series of videos that took you, let's say 30 minutes to do, 3 videos and you got paid $20,000 or euros or pounds or whatever it is. So track the time, track the, just the gig and be able to really provide this as documentation. So I would say looking at this list, the ones that we use most often for our content creators are 1, which is the starring role for distinguished companies, 2, which is the starring role for distinguished productions, and expert recognition, where we can we can help with a series of letters from, let's say, somebody really high in the beauty brand or other content creators, things like that. They're generally the ones that we use. And we can use other ones as well. So if you had a video that did like extremely well, we can potentially use that as major commercial success. If you do have press, we potentially would use that, but again, it's not required. Just again to note on number 1 and 2, we need to show that this happened in the past and in the future. So if you did work with that beauty brand, showing that they would be interested in working with you in the US, if and when you get here, that would be something that we would like to include as well, just to show the potential for this to happen in the future, the high potential for this to happen in the future, to show that we're checking that box. And it's important to remember it's not just in the past, we need to show that this will happen in the future as well. So that's like all of this together really summarizes the first bucket for your O1. And so how do we kind of figure this out? Well, we generally will do a consultation with our clients from the outset, where we'll do a video through Zoom and we'll do a consultation with you and we'll kind of go through all the evidence, we'll hear about your background, figure out what exactly you want to do in the US, and we'll kind of talk about the evidence that we might have that would fit bucket 1, 2, and 3. We generally go for the 3 best criteria, maybe 4. as opposed to trying to like throw everything at the wall to see what sticks. I personally am not a fan of doing that. I've seen, other people do that, and I just think you're more likely to get pushback if it doesn't really fit you if you're reaching versus just going for ones that are really solid. So this is kind of how we roll. Also, we will give you a complimentary copy of the O-1B guide for content creators and influencers. It is really helpful when people have read this before our meeting, so that they have a kind of a good foundational, idea of the O, and then we can get straight into applying the criteria to them as opposed to us explaining some of, the fundamentals. So if you can do that ahead of time, it is helpful. It will just make the consultation be more efficient and more productive for you. So from previous webinars that we've done, these are some of the questions that we got. So people have asked, what kind of letters do you need from experts? Who should write the letters? Do they need to be all in the US? Things like that. We generally recommend about 6 to 8 letters or 6 to 8 experts. We can help with, just letting you know what should be in them in terms of the content. Ideally, we have at least one of these based in the US, so that's important, but it's certainly fine if the majority of them are based from outside the US. Ideally, they are experts, they're writing a letter because they're experts in either the field or an adjacent field, or, let's say in the beauty influencer, they may be working for one of the beauty brands, or they may also be another content creator in the beauty world and can talk to how your content is, getting a lot of traction and a lot of engagement, and you are considered a leading content creator. But we will definitely help you, and we will advise you on, like we tell people to give us maybe a list of 10, and we will advise, okay, of this 10, let's go with these 6 or 7. And maybe, that's kind of how we'll help advise you on that. Do you need much press? So you don't have to have press. But if we are going to go for press, it needs to be about you and your work. So not some random quote about how you're training for the marathon unless you're like a fitness influencer, right? It should be about you and your work, and we want to go for major press. It can be outside the US, and more often than not, if you're not in the US, they are going to be publications outside the US, which is fine, but we need to show the circulation statistics and things like that to show that they're meeting what we would consider to be major outlets. Okay, so second bucket is, so that's a lot on the, let me see, somebody asked a question here. Oh no, so somebody said, oh, Melly from our team said, surprise, you're getting a complimentary copy of the O-1B guide. Yes, you are. And we will send you a complimentary copy of that guide. I hope you love it. We worked really hard on it. And I think, well, I'm pretty sure it was the first, maybe the only O-1B visa guide for content creators and influencers. But yeah, we're very proud of it and hope that you like it. So bucket number 2 is about the petitioner, sponsor, employer. This is very much a one-on-one kind of analysis to see, what are our options? Do we have any options right now? Or if not, we can create an option. It depends really on what you want to do and how you envision kind of your career in the US. What does that look like for you? But the scenarios really are, a company can sponsor you directly for an O1 based on a specific job offer. So let's say you were getting hired by like TikTok to be like a content creator or something like that. That probably like a direct employer employee kind of sponsor. Or if, I know some brands are hiring in-house content creators, if they wanted you to be in-house on their team, that would probably be employer employee. You can also have an agent petitioner where somebody can file it on behalf of multiple employers. An agent for a foreign employer, another option, but our favorite option is for you to set up your own company in the US and have that act as petitioner. I don't have enough time to go into why that is by far the best option, but it can give a ton of flexibility. And that is generally the option that we would advise people on. We don't handle the incorporation because we only do immigration in our firm, very deliberately only do immigration, but we can definitely give you, referrals for somebody that does. And I just think this is the best thing. Also, from a liability point of view, you working through a company in the US is probably going to be smart as well. So this is bucket number two, some type of petitioner, employer, sponsor situation. More often than not, we're recommending you set up your own company. And bucket number three is that you're going to continue to work in your area of extraordinary ability. So, for example, let's say you're a model in Europe and you can, meet all the criteria for like in the past in your modeling, things like that. But if you're not going to come in to continue to be a model, to work in your field of expertise, well then, you're going to have an issue with showing that you're going to continue to work in your area of extraordinary ability. This is very much related to bucket number one. If you recall, we need to show past and future, and this is where it also kind of comes in to play. You cannot have what's known as speculative employment. So the government will not give you a 3-year O-1 visa, which is the max you can get, unless you prove what you're going to be doing for the duration. And we can kind of advise on how that would be structured. You might have an employment contract with your company. You probably have letters of intent to hire. If you've worked with brands that are global, they might also want to work with you in the US. And we can kind of talk to you about that. O1A versus O1B, there's more flexibility with the O1B in terms of like adding additional gigs post approval. There's some benefits there. So, but yeah, you're not going to get a 3-year O1 unless you have some idea of the work that you're going to be doing. And I have heard, we haven't seen this, but that speculative employment has become a kind of a hot topic for this administration. So we just want to make sure that we're really being proactive about providing evidence like that. Okay, so this is probably the audience here is for people who have not had an O1, but sometimes this comes up about renewals. So the O1 visa can be up to 3 years, but again, showing that you have work lined up for that period. What's the success rate? It's normally very high, at least from our firm, but and I think in general O1s have a higher approval rate or have a high approval rating. We have seen some more scrutiny with this administration. So you really need to make sure you're putting your best foot forward. And on that note, we are absolutely thrilled to share that we have a new senior attorney that started today. She has spent years, Jamie is her name, and she may be on the webinar today. And we're just so excited that she has joined our team because she has spent years working in the USCIS, so in the government agency that essentially adjudicates these cases. She has spent years on that side of the table, and we're just thrilled that she's joined us with her incredible expertise and insights, because no doubt the scrutiny has been increasing, and we're just thrilled to have somebody like that join us. So you'll be seeing more of Jamie in the coming days, weeks, months, and I know you'll join me in welcoming her, but she's just an incredible asset to our team. So welcome, Jamie, and we're thrilled that you're here. Okay, renewals, I'm not going to touch on that because, okay. There's also a green card version of the O1. It is the EB1A Extraordinary Ability. The standard is higher. You can self-petition, but again, you need to show work in your field. We also have seen the scrutiny increase on these as well. And this is why it's great to have Jamie join us. And so we can strategize ahead of time in relation to, the best filing strategy, because this is an art form. It is not every attorney or firm is going to approach these cases in the same way. So it's just really important that you're getting somebody that knows this option really inside out, but also knows your field and how to apply this option to your field, and kind of knowing the significance of the evidence, whether it's like a YouTube play button or just certain kind of like analytics in the back end of these platforms to show like views and engagement and like, how watch minutes or whatever it is, it's that kind of stuff is important. Because really we need to tell your story to the government and prove that you are an extraordinary content creator. So this is the list of the EB1A green card criteria. you'll see there's some overlap. I will say there's more overlap between the O-1A, which is the business one, the business science one, versus the O-1B, but there's still some overlap where we're showing like that lead and critical role, that high salary, the commercial success, we're seeing those press as well, those other ones there. So as mentioned, we're thrilled to offer you a complimentary copy of the O-1B guide. I hope you enjoy it. If you do get a chance to read it, would love some feedback on it, because it was something that near and dear to our hearts, and we worked hard on it. So would love to know what you think. We can send you an email after the fact. Whew, okay. Think we're done. It was a little bit longer than half an hour, 45 minutes, but I think it was helpful. Hope it was helpful. You were so welcome, Rachel. Thanks for coming. I'm glad everybody was able to join today. We love these cases, and but otherwise, follow us on social media. Let us know, and then maybe book a consult if you want to chat about it further. Our team would love to help you, and we will be ready and willing to assist you. But that's all I have for now. Okay, take care, everybody. Bye.